all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-1765. Darrell Wilcox, individually and as representatives of the class of participants and beneficiaries in and on behalf of the Georgetown University Defined Contribution Retirement Plan, the Georgetown University Voluntary Contribution Retirement Plan, and Michael McGuire, individually and as representatives of the class of participants and beneficiaries in and on behalf of the Georgetown University Defined Contribution Retirement Plan, the Georgetown University Voluntary Contribution Retirement Plan appellants versus Georgetown University et al. Mr. Nestico for the appellants, Mr. Never for the appellees.
Good morning, counsel. Counsel for appellants, do you wish to begin?
Yes, Your Honor. Thank you, Your Honors. Good morning and welcome to the post-COVID world of appellate argument. My name is John Nestico. I'm an attorney with the firm of Schneider, Wallace, Cottrell, Konecki, attorneys for plaintiffs' appellants. Your Honors, the issues in this case should not present even a close question. The complaint contains specific and detailed allegations that the participants in the Georgetown plans were paying excessive and unreasonable fees for administrative services. In fact, on average, they were paying in the range of hundreds of dollars. In the case of...
Counsel, as you know, the first question we have is whether we have jurisdiction.
Yes, Your Honor.
And of course, you know that appellee has argued we do not. So do you want to address that issue?
Yes, Your Honor, of course. The order that was entered by the district court was very specific, explicit, and unambiguous, and that is that the court dismissed the complaint without prejudice. The precedents in this circuit and in others make it very clear that unless the action is dismissed without prejudice, that it is not a final and appealable order.
I understand your point because we have said generally, but we've said that in specific factual context. And of course, appellee has argued the context here is different. So from my point of view, the question is, given the authority that you have cited, what weighs in your favor in terms of saying that the district court intended that her dismissal was a final appealable order?
A couple of points about that, Your Honor. First, defendants rely significantly on the language of the opinion related to the order. And the fact is that there were numerous claims in the complaint and addressed in the opinion that were factual based. For example, the court challenged our assertion that record-keeping services could be obtained for roughly $35 on average per participant, but failed to address entirely the allegations that participants were paying hundreds of dollars. We also addressed that. We were able to address that in our proposed amended complaint, where we cited additional factual evidence, including national surveys supporting the $35 claim. Another claim was the district court failed to address entirely the standing of participants in the TI.
Does a district court have to explain why it's dismissing a case?
I'm not sure of the answer to that, Your Honor.
If it's summary judgment, there's no requirement in the federal rules that the district court explain itself.
Well, Your Honor, I think...
Isn't our review de novo review?
Yes, Your Honor, I believe it is.
Yeah, so no matter what the district court says. Listen, I want to cut away a few things. Can you ever have an action without a complaint in the federal system?
I don't believe so, Your Honor, but
I agree. I mean, it's like having a smile without the cat. And if you don't have a complaint because it's been dismissed, how can you possibly have an action?
Well, Your Honor, the decisions in this area clearly distinguish between the dismissal of a complaint and dismissal of the action.
Some of them do, and some of them don't. There are, by the way, I mean, are unpublished orders in cases dismissing them or affirming under Rule 34J as our local rule. There are at least close to 100 of those cases that were dismissed. The complaints were dismissed without prejudice, and we rendered a merit opinion on them.
All Your Honor, I can do is cite to Murray versus Gilmore, which
I know Murray. Yeah.
Dismissal of an action, but not dismissal of a complaint, is a final appealable order.
Yeah.
And I think the distinction is that if the complaint can be resurrected by the allegation of sufficient additional facts, then the court should freely allow amendment of that complaint.
Yeah, but yours can't because you were out of time.
That's certainly the defendant's position, Your Honor. But as I said,
28 days, and you filed in 30 days.
That's only if the dismissal of the complaint without prejudice actually is determined to be a final appealable order. If it is not, then, and based on our arguments about it, I think that that's the essential question.
Well, just to, I don't want to take up all your time, but just to go back a little bit, the idea that, well, if the complaint can be repaired through an amendment, then it's not, the dismissal of the complaint is without prejudice, not a final order, runs into all kinds of difficulties, not the least of which is, how do we know whether it can be amended without or repaired through an amendment? How do you know? And you don't necessarily know exactly why the district court dismissed the case, because there's no requirement the district court even give an opinion on that. So the commentators say this is a total morass. It makes no sense, and ought to be straightened out. Maybe yours is the case to do it.
Well, Your Honor, in this case, the district court did provide reasons why it was dismissing the complaint. For example, with respect to the allegations about excessive fees, the dismissal was based on lack of standing because neither of the two plaintiffs had invested in the Vanguard funds, but both of the plaintiffs had invested in the TIAA funds, which we also alleged charged excessive fees, and the court didn't even address that particular claim.
Well, let me ask you, Appellee argues that looking at the order, which I take to be a Rule 58 order, that as to your allegation regarding record-keeping fees, that it failed to state a claim because the theory, according to the district court, was entirely speculative, contrary to case law and common sense, and does not warrant discovery, close quote. How did you understand the district court to view that? In other words, doesn't that support Appellee's view that the district court had rejected, for example, the legal theory behind your case?
Your Honor, I think we understood it to mean she explicitly said that she rejected the proposition that record-keeping fees for these contracts could be obtained at $35 per participant. But she didn't reject at all the allegation that these plaintiffs were paying up to $300 per participant. And that, by the way, is only on average. When you, as we did in our proposed amended complaint, when you translate that down to the individual level, we have plaintiffs who might have a $500,000 account in the plan who are paying $1,600 per participant. So at what point do the facts overwhelm that assessment?
Do you agree then that if the entry on the docket saying this case is closed, the case is closed, is something this court should consider, then you lose?
Well, Your Honor, we reject that proposition, of course. That's just an administrative filing that it doesn't seem to be tethered to the actual order of the court. And the other thing I would like to mention about that is defendants did not ask for dismissal of the action. Their motion for dismissal was to dismiss the complaint, and they certainly failed to ask for dismissal with prejudice. The court relied significantly on the Churalski
motion to dismiss.
On the motion to dismiss.
The record, but I pulled it up on the docket. It did ask for dismissal with prejudice, dismissal of the complaint with prejudice.
The actual motion to dismiss, Your Honor, I believe specifically requested only motion to dismiss based on 12b1 and 12b6. And there was no mention in the motion to dismiss at all, or in the memorandum in support of the motion to dismiss, that the action should be dismissed with prejudice. And that was the issue in Churalski, where the plaintiff had filed an initial complaint that was 109 pages. The defendant filed a motion to strike the complaint, and then they filed a subsequent, with leave of court, an amended complaint that was not equally as long, but basically did not take care of any of the excessive pleadings that were in that case. And the court, the defendant then actually requested a motion to dismiss with prejudice that was granted by the court. To Judge Randolph's question about how do we know, if the district court were aware of these cases as they submitted as the court submitted in their subsequent memorandum opinion, then it would clearly have been possible to be more specific in the original dismissal order, rather than simply say that the complaint was dismissed without prejudice, which from our perspective and the perspective of really the majority of the courts that have addressed this issue, allow for or should allow for leave to amend, especially when it's with respect to the first complaint, and especially when there are significant factual issues that were addressed by the court in that memorandum opinion.
You want to save the rest of your time for rebuttal, or do my colleagues?
Yes, Your Honor, I would like to do that. Thank you.
All right. All right, we'll hear from counsel for appellee.
Thank you, Judge Rogers, and may it please the court, Brian Netter for Georgetown University et al. If I could begin, Your Honors, with Judge Rogers' first question to counsel for the appellants, which was, how are we to know that in this particular case, the action was closed? And I think that there are a number of considerations here. The first of which is that Judge Collier signed an order that she posted to the docket saying this case is closed. The second is that...
Counsel, let me ask you, when you say the case is closed, in your reading of that, that is indicative of the district court having stepped away from the case and it's a final appealable order. But as you know, other circuits have viewed that language to be ambiguous and may only refer to an administrative matter, having nothing to do with whether the order is a final appealable order. What's your response there?
I don't think that I gather that Your Honor is referring to the string site of cases from other circuits and appellant's reply brief. And we don't share the appellant's interpretation of those cases. Every single one of those cases was clearly an administrative closure in which there was further action anticipated. The vast majority of those cases were circumstances in which a court had granted a motion to compel arbitration and was holding on to jurisdiction for the post-arbitration proceeding. There isn't a single case the plaintiffs have cited from this circuit or from any other circuit where a case was dismissed, there were no further proceedings contemplated, and that dismissal, with or without prejudice, was deemed to be a non-final order.
Well, in their opening brief, they cite the Seventh Circuit case, all right, saying that, you know, a docket notation can't change an order that is not final into a final appealable order. That's what I'm focusing on here, as to how are we to know, A, assuming we take the docket as under the rules authorizing the clerk's office, or in this case, as it's argued, presumably the district court's law clerk, to add a notation that is not anywhere in a statement by the district court herself in any of her orders or the memorandum opinion in January.
Well, Your Honor, the orders that are posted by the district judge on the docket are orders of the court. There are frequently orders that have no attached document at all, and those are just as binding as a link on the docket to another document.
Suppose the law clerk had said on the docket, paid $25.
So if the court's question is if the law clerk, I guess there are two aspects of this. One is distinguishing between the law clerk and the judge. And we know in this case that this order came from Judge Collier, because in her subsequent order denying the Rule 59 motion is untimely, she took ownership of that order. So if the question is, what if we have a law clerk acting beyond the authority of the law clerk, that's just not a circumstance we have here. In any event,
Counsel, what I'm really focusing on is, as of the January memorandum opinion and order, what signal, or what should we find in Judge Randolph's view, signal that this was a final appealable order, where what I'm describing as Rule 58 order says, for the reasons stated in my memorandum opinion, I grant the motion to dismiss, and the complaint is hereby dismissed without prejudice.
So, Your Honor, three things. First is we do believe that the language, this case is closed, is significant because it describes what the district court's intent was, which under Soralski is the governing standard. Second of all, the absence of any date or mention of the prospect of amendment is also a significant consideration here. In my experience, when a court dismisses a complaint without prejudice but thinks that there is some amendment that's possible, the court will set a 14 or 21-day deadline for the case to move forward. Here, there was no mention of that at all, and that also does.
Is the court required to do that, though, in order to keep the case open?
Well, I don't think that the court is required to set a particular deadline, but the court can also just say that it anticipates that it's going to allow for the plaintiff to have some opportunity to replead, which was what happened in Murray versus Gilmore, where Judge Sullivan said, I'm going to keep this case open because I'm going to wait for an amended complaint once the plaintiff can develop the argument there. In Soralski, the court dismissed the case without prejudice, contrary to what Mr. Nestico said, for a reason where the complaint clearly could have been amended again, because it was dismissed for failure to plainly articulate the allegations, to plainly state the claim under Rule 8. And in that case, the district court indicated that it dismissed the action as opposed to just the complaint because the plaintiff had not indicated any desire to amend the complaint before the case was dismissed. And the same thing is here too, that the plaintiffs could, upon reading Georgetown's motion to dismiss, they could have amended their complaint there. They could have indicated in their opposition that there were additional facts that they had available. It's also important to keep in mind here that this case is not an isolated case. This was, if I'm counting correctly, the 17th class action lawsuit that was filed against a large private university alleging that the retirement plan had been misconfigured in basically the same way in each case. So I think it's a reasonable...
Mr. Netter, may I interrupt you? If the only thing that happened, as you say, is the judge issues an order dismissing the complaint without prejudice, and the next day the plaintiff files a notice of appeal, and then a week later files a motion to amend the complaint, is the notice of appeal null and void retroactively?
It's not null and void. So the federal rules contemplate that if there's a post-judgment motion that is pending, that effectively the notice of appeal doesn't ripen until that period has been delayed. If the assumption of the court's hypothetical is that this was a dismissal of the action and there were no contemplated proceedings.
I do not understand what the distinction between. I know that it's been said by in Murray and well, I think Murray may have misunderstood the Chorowski case, but in any event, I don't understand the distinction between dismissal of the action, dismissal of the complaint. You can't have an action unless you have a complaint, and if the complaint's dismissed, then that's the end of it. It's pretty simple. Yeah.
We certainly agree with that, Your Honor, but the way that we've tried to reconcile these cases that suggests that there is a world in which a complaint can be dismissed, but the court can anticipate future action such that it's retaining jurisdiction. The distinction that we draw is that there's no indication anywhere here that the court was intending to hold on to the case. And
is that what's the name? I've forgotten the name of the Supreme Court per curiam case where the judge dismissed the complaint without prejudice, but granted leave to amend in 20 days or 20, I don't know, some period of time, and no amendment came in. And then 2 years later, a notice of appeal was filed. What's the name? Do you recall the name of that Supreme Court case?
I don't. There's a 1949 Supreme Court case that talks about jurisdiction after dismissals without prejudice.
That's Wallace?
That's Wallace, right.
Right. No, I'm not talking about Wallace. There's another, I don't have it on the tip of my tongue, but, well, go on. So.
In any event, in order for the dismissal here to have been non-final, the district court would have had to have some ongoing connection to the matter. But here there was no such ongoing connection. As Judge Collier explained at the time, she was closing the case, which is not something that ordinarily happens with a dismissal of a case without prejudice if the court contemplates that there's going to be an amendment forthcoming. The plaintiffs had not requested any sort of amendment. There was no indication in the language of the opinion that there was some easy way to amend the complaint. And one worrisome aspect of the appellant's position here is the assumption that whenever there are deficiencies in the allegations, that there's always some way to just make up new allegations to plug that hole. In my experience, at least given that we have Rule 11, that's not the case. And when the plaintiffs decide to stand on their complaint, and this is a very lengthy complaint with I think more than 100 paragraphs of allegations, they're putting their best case forward. And if that case does not legally state a claim, as was the case here, then the case is over. And that surely is the way that the district court understood the proceedings to be here. And we view the circumstance to be governed by Soralski, which again was a dismissal without prejudice, in which the court indicated that even though there was a possibility, even though it was theoretically possible to amend the complaint again, because the plaintiff had not indicated that it had future amendments to make, the dismissal without prejudice was a final appealable order.
In this string of cases under ERISA, in other circuits, the complaint has gotten further, and indeed one went to trial, so that where the district court here says your allegation is speculative, doesn't that invite the plaintiff make clear that no, it's not? Look at what other schools are doing. Or your point is that, just trying to understand the theory here, that given that we have this somewhat murky area and the effort by this court, whether you agree with it or not, to sort of provide some clarity by talking about dismissal of a complaint as compared to dismissal of an action without prejudice, that there's a burden on the plaintiff in order to make certain that it isn't missing its opportunity to appeal, to either either file that protective appeal or, as I think your brief suggests, check with Chambers, see what was really going on, what was intended. And that rationale, as I understand it, does not require this court to opine on the language, the case is closed, and whether or not that type of notation appears properly in the docket under Rule 79.
So there were a bunch of questions there, Judge Rogers. Let me try to unpack them. First of all, we do agree that there are multiple ways that the court could rule for Georgetown here. One of them, a very straightforward way, would be to rely on the language the case is closed. But even if you take that language out of the picture, we do believe that the dismissal without prejudice with no provision for amendment would also have constituted a final appealable order that started either the 28-day clock for Rule 59 motion or the 30-day clock to notice an appeal. Now, I do want to go back also to the court's reference to the case that went to trial, which was Sacerdote versus NYU, because we draw precisely the opposite inference. So what happened in the NYU case was, in a bit of a rocket docket moment, that case was sped along to trial, and Judge Flores conducted a 2-week bench trial and then wrote an opinion and said, oh my goodness, there's nothing here. All the allegations in this complaint presuppose that NYU could have achieved something different, but a plan that was starting out fresh could have gotten something different. But a plan that started out like NYU could have looked nothing like it. This is fanciful, it's fictitious. So when the district court in this case is reviewing the complaint against the backdrop of those trial findings and the NYU case, it's reasonable, we think, to evaluate the plausibility of the complaint by seeing whether the plaintiffs could come forward and make allegations that would surmount the findings of the trial judge in the NYU case. So because the plaintiffs could not actually allege there were other universities that had these PIA annuities and that had similar lineups that were able to come up with a new plan that looked like they wanted, there's no reason for the case to move forward, despite the fact that the NYU plaintiffs had an opportunity to conduct a discovery and to develop the facts. So that, in our view, is really a further justification for why it made sense for the case to be over upon the dismissal of the complaint.
Mr. Netter, I just recalled the name of the Supreme Court per curiam case. It's Young, or J-U-N-G, 1958. Are you familiar with that case?
Not off the top of my head, Your Honor. If the court would like for us to file a letter about it, we'd be happy to.
What happened is that it was a dismissal without prejudice, but with leave to amend for 2 weeks. And the time expired for amendment, and 2 years passed. And then the plaintiffs appealed, and the Supreme Court allowed the appeal as timely. How do you explain that?
Well, again, Your Honor, it's hard for me to answer that question without immediate familiarity of the case. And we would be happy to submit a letter. And one would think that modern jurisprudence, there are some circumstances in which a complaint is dismissed without prejudice, and there is an appeal, or there is a time period provided for amendment. And courts have found that if the plaintiff does not amend within that time period, that the expiration of that time period constitutes when the order becomes final. We can certainly look into this Young case and figure out if it remains good law. But it's hard for me on the spot to try to understand how that can be reconciled with the other more recent binding authorities that we've cited in our paper.
Okay, thank you.
If there are no further questions, we would ask the court to dismiss the appeal for want of jurisdiction, or in the alternative, to affirm.
Thank you.
Judge Randolph, I would like to address your question about the difference between a complaint and an action. I think there is a very clear distinction between those two things. The complaint is alleging facts that supports a particular claim of liability. And the question is whether the factual allegations in that complaint support the claim of liability. The action is the claim of liability. And when an action is dismissed, the court is making a decision that no factual allegations and no amendment to that complaint could support that claim of liability.
Can there be an action without a complaint?
No, Your Honor.
And if there can be, will you please explain to me how that is possible?
Your Honor, I think it's looking at it from two different perspectives. I agree that there cannot be an action without a complaint. The question is, does the complaint support the action? And there can be various iterations of the complaint. So the real issue is, can that complaint be revived by the allegation of additional facts that would support the action? And I think there are numerous instances in this particular case that indicate that would be true. One is, of course, with respect to the issue about whether the claim regarding the limitations on the TIA traditional annuity were barred by the statute of limitations. Defendants noted in a footnote that it was barred by the 3-year statute of limitations, and the district court seized upon that to claim that that applied. The fact is, however, that—
May I interrupt you? You triggered something that I hadn't really focused on. I think it's an interesting point. Did the defendants here file an answer to your complaint?
No, Your Honor.
So any amendment that you have would relate back, right?
Correct.
Okay. All right. Thanks.
So that particular issue, the 3-year statute, depends on whether the plaintiff had actual knowledge of the claim, of the illegal activity, not just whether there were restrictions on the annuity contract itself, but whether, in fact, those restrictions violated the law. So that is clearly a factual issue that could have benefited by additional facts or additional factual inquiry. And the plaintiffs never had an opportunity to address that issue. So again, to your point,
or district court in any way that it wished to file for leave to amend the complaint?
I'm sorry, Your Honor, would you repeat the question, please?
Did the plaintiffs indicate to the district court in any way what you're telling us today, namely that there were allegations that could have been made to address the concerns of the district court, and therefore the plaintiffs would be filing a motion for leave to file an amended complaint?
We did not in advance, but we did within 30 days of that.
I understand that, but I'm talking about before that, because you ran into that 28-day problem. And I know you say there was no time limit to a Rule 15 motion, but still.
Well, again, Your Honor, based on precedent from multiple districts, our view was that that initial opinion and order, which simply dismissed the complaint without prejudice, was not a final appealable order, that therefore we had a reasonable time to file our motion for leave to amend.
No, I understand. And, you know, there is a way to read the rules to say that the rules have been amended to try to make the Rule 48 order clear, so we don't have cases like this. But my point is that at least the law in this circuit and other circuits is not so clear. And therefore, was there not some burden on you to try to seek a clarification rather than risk that you might lose your opportunity to appeal?
Your Honor, I don't believe the burden should be on the plaintiff in that particular case, especially when the cases are pretty clear. And take Choralski. The court in Choralski told the plaintiff that unless they complied with the court's order regarding the amendment to the complaint, that the action was going to be dismissed with prejudice.
So you think the burden is on the court, the district court?
Yes, Your Honor, I do, to make the order clear. Otherwise, it becomes
right. Well, that's my point. Whose burden is it to seek clarification of the district court's order if it's not clear? And I assume, and this is pure speculation on my part, that whoever prepared the docket entry was trying to signal that. At least that's one way to read that docket entry.
Well, Your Honor, I also go back again to my point that when defendants filed a motion to dismiss, they did not seek dismissal of the action without prejudice. They specifically sought dismissal of the complaint based on 12b1 and 12b6, and therefore the court's original order simply granted defendant's motion to dismiss, and that the defendant...
I said you did not include the defendant's motion to dismiss in your appendix. And I'm not saying you were required to, but given the nature of this case and our trying to figure out what's going on, I went to the docket to see what the defendants had said in their motion to dismiss. I'm looking for my copy right now. But I thought they had very clearly, and I can look again, that they had moved to dismiss the complaint with prejudice.
Your Honor, I don't believe that's true.
Point. I can clarify that later. All right, anything else? Or my colleagues, any questions?
No,
No.
not for me.
All done. Anything further, counsel, for appellant?
Your Honor.
Thank you very much, counsel. We'll take it under advisement.
Case number 19-3100, United States of America versus Francisco Cabaja, also known as Dalmata appellant. Mr. Gilbert for the appellant, Ms. Kirk for the appellee.
Good morning. Good morning. Counsel for appellant. Hi, Mr. Gilbert, are you able to hear me? Apparently not.
How about now, Your Honor?
Good. Can you hear me?
Yes, Your Honor.
All right. Would you like to proceed?
Yes, Your Honor.
Thank you.
My name is Richard Gilbert. I have represented Mr. Carvajal Flores since he was presented in Washington, D.C. back in 2011. So it's a relationship that goes back some time. I have asked to reserve 2 minutes for rebuttal. Let me just start by saying that the original sin, if I can use that term, that gives rise to all of the legal issues in this case has to do with the government's insistence that Mr. Carvajal Flores plead guilty to the RICO conspiracy.
Well, you're not raising any Rule 11 issue here, are you?
No, Your Honor.
So he pled guilty. And he pled guilty, acknowledging the statement of fact presented by the government in support of the plea agreement.
Yes, that's correct. I do think that it's important to keep in mind the language that appears in the stipulated statement of fact, particularly its use of the passive voice when it talks about things that were common knowledge or things that Mr. Carvajal Flores was aware of. I think both of those expressions are really expressions that are more applicable to the issue of foreseeability rather than any specific agreement that he might have made. And over 25 years ago in the United States versus Saro, this court made it clear that foreseeability was not enough in determining responsibility after a general guilty verdict on conspiracy. And so we have suggested that there's actually no indication that Mr. Carvajal Flores actually agreed to have anything to do specifically with drugs. That's why we've suggested that his offense level should be the minimum of 6 based on the drug quantity table.
Well, counsel, I mean, you know better than I, your client made certain admissions about what his role was all about. And it certainly had to do with this drug trade.
Your Honor, to be precise, I don't think that he made those kinds of admissions.
Why was he keeping the routes open? Why was he, trying to disrupt competition? I mean, we can't just ignore what your client said.
Well, I think we've tried to present in our brief that in carrying out the activities of the Zeta cartel, there was a wide variety of nefarious activities that the cartel engaged in. And drug trafficking was only one of them. I think it's significant that the government and the pre-sentence report writer, and eventually the judge, concluded that Mr. Carvajal Flores, for his actions in the state of San Luis Potosí, was responsible for all of the drugs imported by the Zeta cartel during the period of time that he was a member of the conspiracy. I've tried to provide page 225 of our appendix, a map prepared by the DEA 7 as to the areas controlled by the various cartels in Mexico. And as you can see, the Zetas controlled the state of Nuevo Leon, which is right across the border from the city of Laredo. And also the Zetas controlled a large share of Tamaulipas, the major city of which was Reynosa, which is right across the border from McAllen, Texas. So drugs would have entered the United States, not necessarily having anything to do with San Luis Potosí, which is where Mr. Carvajal Flores was conducting activities for the Zeta.
Mr. Gilbert, I'm interested in your arguments about vacating the guilty plea under Section 1114. Why can't Mr. Flores raise those issues on collateral appeal? Why isn't that the appropriate way to raise those issues?
Well, we would certainly, of course, like this court to consider it, because we think that if you force him to go through collateral appeal, the case may not get resolved before he's released, because there's nothing to expedite a 2255 motion.
Mm-hmm. And can you say some more about why you think that this is plain error under Rule 52B?
Yes, Your Honor. After Garcia Soto, in this circuit, the law is that a violation of Section 1114 is not a crime punishable under United States law because of the extraterritorial application. So that's the law in this circuit.
Has rehearing in bank been decided in the Garcia Soto case?
Yes, Your Honor. My research indicates that the government did file a petition for rehearing, and this court denied it.
Okay, thanks.
So I think that's established law down the circuit. And so after the Supreme Court's Henderson decision, what's determined to be plain is what's plain at the time of the appeal. So he's appealing now, and the law in this circuit is that those two convictions under 1114 are not punishable under United States law. So that's the error, and that's the law now. That's why we say it's.
Yeah, but the government says if he hadn't pled guilty to 1114, then and we couldn't charge him with that because it didn't have extraterritorial reach. We would have charged him with 1116. And under the sentencing guidelines, he would have gotten exactly the same score as he got under 1114. What's your answer to that?
Well, of course, the protected person, which is the 1116, only applied to the agent that survived, Special Agent Avila, because he had diplomatic status. It did not apply to Special Agent Zapata. And so
what?
There would be no basis to convict my client of accessory to the fact of murder. It would only have been the attempted murder. So the sentence would not have been the same in any event because of the way that you view multiple charges. Assuming it all depends on what you decide the correct sentencing guideline for the RICO conspiracy is. Because if you agree with the pre-sentence report, then the sentencing guidelines for the other two convictions are irrelevant because the sentencing guideline of 50 reduced down to 43 is much, much higher than the 30 and 29, which would be the levels for the murder, accessory to the murder, and accessory to the attempted murder.
Did you say in your brief that vacating the sentences under 1114 would not amount to anything because they were concurrent?
No, I did not make that specific point in our original brief. I am trying to reserve some time for rebuttal.
All right. If my colleagues have no further questions, we'll hear from the government.
Good morning. May it please the court. This is Suzanne Kurt on behalf of the United States. Unless the court asks otherwise, I'd like to proceed with the issue of drug quantity. And I would like to first talk about the defendant's objections to that. Number one, he claims that he's being responsible for the drugs attributable to the entire cartel. That is not correct. Number two, he said he had no role in transporting drugs. That also is not correct. And number three, he claims that he had nothing to do with the involvement of methamphetamine, but that is not relevant. Turning first to the drug quantity. As Judge Rogers noted, in his statement of fact, appellant acknowledged that the Los Zetas cartel transported, and the word is multi-ton quantities of cocaine every single month to the United States. Now, when the court decided drug quantity in this particular case, it adopted level 38. For level 38, you begin with 450 kilograms, or which is only 1/2 of a ton. In the pre-sentence report, which the court adopted, the court stated that the minimum level that he was responsible for was 1 ton, basing on the notion that multi-tons were transported each month. I think I inadvertently overstated my burden, or the government's burden, of proof here, because when the judge adopted the pre-sentence report, he was really adopting the notion that it was 1 ton that they were responsible for. I didn't realize until reviewing for the moot that the pre-sentence report writer did not times that by the 15 months that the defendant participated in the cartel. So he is not being held responsible for multi-tons of cocaine. He is only being held responsible for 907 kilograms, which is 1 ton, which is well above level 30, the amount required for level 38. Secondly, appellant argues that he should be responsible for only a level 6, but that is an incorrect application of the guidelines. He pled to an offense of 5 kilograms or more. And the guidelines require you to begin with what is the offense level applicable to the offense of conviction. That is at least a level 30. And then in terms of his own involvement, there, as Judge Rogers indicated, there are numerous circumstances set forth in the statement of facts stating that his role was to protect the cartel's drug smuggling routes into the United States. That was his purpose in getting hired by the Los Zetas cartel. That included, in the appendix at page 45, protecting the drug smuggling routes in San Luis Potosi State, as well as others. And he specifically acknowledged that San Luis Potosi State had lucrative drug trafficking routes into the United States. He acknowledged numerous times that his role was to eliminate competition for land drug routes. He stated that when he started working for the cartel, he gathered information on rival cartels competing for the drug routes. That would be in the state where he worked. Then he worked his way up to be a commander, and at that time, his role was still to protect the lucrative highways in St. Louis Potosi for those drug trafficking routes. And we have cited to the case, to the court on page 36, page 39 of our brief, several cases from the Third, First, and Seventh Circuit that talk about the important role of an enforcer, such as this appellant was, and why it is appropriate to contribute to him although that didn't happen in this case, all of the drugs that were transported by the cartel. Appellant relies on Cerro, but in Cerro, the court was concerned with two appellants and whether each had joined in the entire conspiracy and whether each was responsible for the amount of drugs that the other person had engaged in. But at the same time, the court recognized that in some conspiracies, each defendant has joined in the overall scheme. So the scope is identical for each. And that is the type of conspiracy that we have here. This man's role was to protect the routes for the entire drug cartel that was going through San Luis Potosi. I'd like to, unless there are no further questions about drug quantity, I would like to turn my attention to Judge Rao's question about the first issue. And appellant has ignored the fact that he did not, this claim about 1114 was available to him when he brought his direct appeal. He doesn't claim otherwise. And this court has said in numerous occasions, and we've cited Henry, Bruce, and Sani, that it's well settled that when an argument has been raised in an initial appeal, it's inappropriate to consider that argument on a second appeal following remand, which is what we have here. Appellant, as Judge Rao asked about...
Could I just explore so I understand precisely? I know you reject his argument about forfeiture as opposed to waiver. But what was his situation? In other words, the direct appeal was filed when?
The direct appeal was filed, I'm not sure of the exact date, but let me...
What I'm trying to get at is when he filed his direct appeal, had this court already decided that Section 114.
No.
So I want to be clear. There's a Supreme Court decision written by Justice O'Connor talking about what a defendant is obligated to raise where there is no definitive decision on the issue, but it's percolating, as it were.
Yes, Your Honor.
What?
Yes. Do you want me to address that?
Well,
yes.
I want to be clear. Is that the argument you're making as to the direct appeal?
Yes, our argument is in the direct appeal, he's making, in Garcia Soto, the argument was that 1114 did not apply extraterritorially. Those sorts of claims have been for all kinds of statutes where the conduct occurs outside the United States. Their arguments, their cases are replete with those kinds of arguments. That was definitely an argument that was available to him. And as the court knows, in Boosley, the court discussed that where those types of arguments are circulating, that it's not an excuse that you didn't bring it. Earlier in the direct appeal was definitely available to him. And as a matter of fact, he made a guidelines argument that was very similar. He made a guidelines argument that he wasn't responsible for the conduct that occurred in Mexico as relevant conduct. My other point, though, that I wanted to bring out in terms of the plain error claim, and we believe this claim is absolutely waived. He relies on this court's decision in Sani, and a quote there where they're talking about the plain error doctrine applying, but he misreads Sani. That quote from Sani is, the court there is talking about the fact that the defendant did not raise a claim about the resentencing. And so, yes, that would be plain error. But if you look at the sentence immediately before that, the court in Sani addresses the defendant's attempt to raise a claim about his sentence that should have been raised in the first appeal. And the court in Sani applies Bryce, which in turn applies Henry, that says it must be raised, it's forfeited, it's waived if it's not raised in the direct appeal. And of course, that's what...
Also, could I just be clear on what the government's position is? In other words, if an issue about the extraterritorial application of various U.S. code provisions is circulating, even though the Supreme Court has said that counsel has to make determinations as to what issues to bring, and if you've got 40 to bring, adding the 41st doesn't necessarily, or the failure to add it doesn't necessarily show an effective assistance of counsel. So I want to understand why, where there's nothing in the way of an overt waiver, except through this legal theory, would the government take the position that it wants an appellant to raise everything that may be percolating out there, even though in the relevant jurisdiction, there's been no decision, and no decision by the Supreme Court. So then the appellate court, us, is supposed to apply the law as it exists at the time we're deciding the case, absent this retroactivity concern. So it's not as though, I'm just trying to understand, is the failure to say, and I raise everything else that may be percolating out there, deemed to be a waiver by the government, as opposed to what appellant is arguing, that it should be viewed as a forfeiture?
No, we are arguing that it's a waiver, Your Honor, because the argument was definitely available to him. I know that in other jurisdictions...
But counsel, can you just take my question as I gave it to you, because that's a critical point to me. Not what other jurisdictions are doing, but what the government in this case is arguing he was required to do in order to avoid this waiver argument, which is a slightly new concept of waiver after Olano and even after Jackson versus Steno. So I'm just interested in it.
No, Your Honor, we firmly believe that he waived it. The argument was definitely available to him at the time of the direct appeal. There were contrary decisions in other jurisdictions, but that I also think Boosley makes it very clear that it was his obligation to raise it at the time of the direct appeal. And moreover, though, what's also involved in that is this was a guilty plea. So as Boozley makes plain, in order to, the arguments that the court's talking about may be pertinent to a direct appeal and an appeal after conviction, but not for a guilty plea. A whole other set of concerns come in with a guilty plea, as Boozley makes clear and as we explained in our brief. So it's not plain error, it's waived. We believe the law is very clear on that, that this type of claim was definitely available to counsel, and therefore it has to be brought in a habeas action in the district court.
I'm
I have
sorry,
what?
just from what you just said just now, do you think, is your waiver argument based in part on the fact that those arguments were percolating and also that he pled guilty? So is your contention also that the guilty plea waived these claims in some way?
Your Honor, I have to be frank. When I first looked at this particular issue, the first thing that popped into my mind was the waiver argument because it had not been raised in the direct appeal. As we were preparing for this argument, and I was working on my moots last week, I was looking at a jurisdictional issue, reading some other cases, and I came across a case called Delgado-Garcia, which brought up that particular argument that you just mentioned, that the guilty plea waives it. I discussed it with my colleagues, and unfortunately, I think it's a slightly different waiver argument that we made in our brief, and to be frank with you, we did not think that it was an appropriate issue to raise in a Rule 28 letter, but it certainly is in Boozley, but we think that the issue of waiver by failure to raise it in the first appeal is very clear based on this court's particular precedents and the fact that these types of arguments are very common in the jurisprudence, that a particular U.S. statute doesn't govern extraterritorially. So there would have been, therefore this needs to be brought in a habeas, in the habeas context.
And my question was different. I wasn't talking about a specific provision of the U.S. Code. I was talking about, is the government's argument that you have to raise any of these U.S. Code provisions that might apply to me for conduct taking place outside of the territorial United States has to be raised. So then I would just list all, the code sections that the government is applying to me.
Oh, no, Your Honor. Our position is that with respect to the 1114 claim that he's making now, that had to be raised in the direct appeal, that specific claim. Because that type of claim was definitely available to him at the time of the direct appeal, and it would have been directly relevant to his claim in the direct appeal, assuming that he could raise it, given the fact that it was a guilty plea, as Judge Brown mentioned.
May I ask you?
Yes, Your Honor.
The brief says that because it's a guilty plea, and I asked counsel for the defendant, that you have to consider what other charges could have been brought if there is a problem with what we have here, which is 1114. And you say yes, 1116, right?
Yeah.
Okay. But how many counts could you get out of the 1116? Just one, right?
Right, that's right. But we
so he's been convicted of 2 felonies, or he pled guilty to 2 other felonies. To replace it with only 1 felony runs into a problem, and the problem is the $100 assessment.
I'm not sure, Your Honor, what
for each felony count, the law requires that the defendant be assessed $100.
Mm-hmm.
So you can't say, well, there's no consequence here because the imprisonment sentence, yes, would be the same, but the $100 assessment would not.
Well, Your Honor, I think the point you raised, these are the types of issues that should be raised in the district court in the first instance. And I would point out that we also, use of a firearm during a drug trafficking crime. We also forewent that. He was charged with that in the initial indictment. And that is, that we believe sentence would have to be consecutive even. So I think that, and of course he has to show that he's not guilty of all more serious charges. And of course he can't make that with respect to the RICO conspiracy either. So I don't think he can't meet the burden that this court discussed in Tasso and Baxter of showing he's not guilty of either equally serious charges or greater charges. And that's our position that's forth in our brief.
Okay, good. Okay, thank you.
Thank you, Your Honor. Are there further questions regarding the other enhancements that the court may have? Otherwise, we would submit on our brief.
Thank you, counsel.
Thank you, Your Honor.
Counsel for appellant?
Thank you, Your Honor. This court in the United States versus Dudley set out the responsibilities of the district court and arguably those of the prosecutor as to being able to make specific findings as to the scope of the agreement. And I respectfully suggest that simply knowing as a general matter that drugs might be coming through San Luis Potosí headed towards the border does not mean that he's specifically agreeing to all of those drugs that come through San Luis Potosí. I think there's got to be some specific findings made, and none of those findings have to do with any specific quantities of drugs. I've addressed in our brief the government's arguments about the enforcer being responsible, but those are cases in which the enforcer was working directly with the head of the drug trafficking organization. That's clearly not the case here, where Mr. Flores at best could be said to be a peripheral enforcer by trying to keep the Gulf cartel off the roads in San Luis Potosí. I do want to argue, I addressed it in my brief, the issue of whether or not the forfeiture argument is waived by virtue of the guilty plea. And I cite the case United States versus Class that I cited in my brief, and it talks about basically the principle that, look, if the argument that you're making about a charge you pled guilty to doesn't involve new facts, we're not arguing that it does, because it's undisputed that the attack on the agent occurred outside the United States of America. I believe that this is a case where, under Class, the defendant is entitled, notwithstanding the guilty plea, to challenge the validity of those convictions. Ms. Kirk didn't have a chance to tell you why the fact that Mr. Carbajal Flores had no personal involvement or knowledge of the methamphetamine is not relevant, because there was an increase in the sentencing guideline precisely for the methamphetamine. So that's unless there's an additional question, that's all that I have.
I just want to be sure I have your citation. How do you spell USC versus, is it Class or Glass?
It's a class, just like an online class.
CLASS?
Correct, Honor. Let me find that for you.
Yeah, it's not in your reply brief.
No, it was, I was trying, when I raised it in my initial brief, I was trying to anticipate arguments that I thought the government would raise later. And certainly the idea that he pled guilty is one of those arguments I was trying to anticipate.
Well, I don't see it in your opening brief either.
I'm looking desperately right now, Your Honor.
Okay, what is the citation?
That's what I'm looking for. I'm sorry.
It's 138 Supreme Court 798, a 2018 decision, Class B United States.
Thank you. So my point really is not that the case didn't necessarily exist, but the government had no opportunity to respond.
Well, the government in its reply brief did not raise the issue of Mr. Carvajal Flores being precluded from asking this court to consider the forfeiture argument. They didn't argue that the guilty plea in and of itself precluded him from raising the plain error issue. I believe that Judge Rogers, you have it right that forfeiture is simply the failure to raise an issue, but waiver requires a more intentional forbearing of an argument. And I don't believe there's any case law that argues that simply because I conceivably could have made an argument that was not yet the law in this circuit, that therefore that's a waiver and not a forfeiture.
Well, counsel acknowledged the earlier point you were making, but comes back and says Boosley, and you say Boosley is inapplicable here.
Well, I think what makes Boosley inapplicable is in Caso, this court tried to divine what the Supreme Court had in mind in Boosley and concluded that the requirement to prove innocence on all the other more serious charges was either a matter of inherent in plea bargaining or was designed to avoid the defendant getting a windfall. Eventually, that's what this court settled on in Baxter, was the rationale behind Boosley. But in this case, depending on how you resolve the sentencing guideline issues, the government was forced him to plead guilty to a offense that, if the government's calculations are correct, carried a life sentence and carried a guideline sentence of life, which is what 43 is. And so certainly that was they got that plea as a result of the plea bargain. So that's a more serious offense, and they were able to extract that from him. So that's why I think Boosley is not applicable, because they were able, as a result of plea bargain, to get him to plead to a much more serious offense than the ones that we're asking for today.
All right. Do my colleagues have any questions?
No.
Thank you, counsel. We'll take the case under advisement.
Thank you, Your Honor.
Case number 19-1235 et al. Davidson Hotel Company, LLC, Chicago Marriott at Medical District /UIC, petitioner, National Labor Relations Board. Mr. Delaquill for the petitioner, Ms. Isbell for the respondent, Mr. Treadwell for the intervener.
Good morning.
Good morning, and may it please the court, counsel, your honors. I'm Mark Delaquill, arguing on behalf of the petitioner, Davidson Hotel Company. The fundamental error in the NLRB's decision in this case is its lack of consistency with prior decisions on the appropriate composition of a bargaining unit at a full-service hotel. First, the decision is irreconcilable with NLRB precedent in Ramada, Beverly Hills. Second, the decision is inconsistent with the board's reasoning in denying a previous petition of the union to certify a bargaining unit including both housekeeping and food and beverage employees at this hotel. And the inevitable result of these inconsistent decisions is a fractured bargaining unit that does not include front desk employees, and that while putatively including separate units of housekeeping and food and beverage, is being treated functionally as a single unit. First, I'd like to address the NLRB's precedent in Ramada, Beverly Hills. Our position is that this case is on all fours with Ramada, Beverly Hills. First, concerning the critical topic of functional integration, both the hotel in this case and Ramada, Beverly Hills employed a single general manager with final hiring and firing authority, as well as final authority over policy at the hotel.
Well,
Second,
in the board reference opinions, Logian and Western Lodging, correct?
it did, Your Honor.
All right. And when you look at those opinions, the board reviews its full-service small hotel case, specifically Ramada, Beverly Hills, Ramada Atlantic, Ramada in West, and it talks about what it looks for to come within that kind of precedent. And it says specifically what it's looking for. And the findings here were that those elements did not exist here in the Davidson Hotel.
And those findings, Your Honor, are unsupported by substantial evidence. And I'd like to address briefly Western.
Counsel, that's a different argument. Her argument was that the board's decision was irreconcilable with its precedent.
That's
I'm saying at least the board cited cases where it distinguished its precedent, including Ramada.
Your Honor, the standard of review for a decision like this, as articulated in Blue Man, Vegas, and other cases, is whether the board's decision is arbitrary or unsupported by substantial evidence. With regard to the board's distinctions of Ramada, Beverly Hills, the distinctions are unsupported by substantial evidence, which makes its decision arbitrary, i.e. irreconcilable, with the Ramada, Beverly Hills cases. And with respect to the Western Lodging and Logian cases, there are serious distinctions that make this case far more like Ramada, Beverly Hills, even on the record the board found. In Western Lodging, there was no centralized management and hiring by division supervisors, which cuts far against the type of functional integration that you see at this hotel. And in Logian, the board's decision was influenced by a factor of which there's no evidence in the record in this case, which is regional industry practice about the appropriate compositions of bargaining units. That was a key factor in several of the decisions cited by the NLRB and the union, including Logian as well as Omni.
All I'm getting at is that there are distinctions, but the findings as to the Davidson Hotel discuss the nature of the management control, the nature of the transfers between employees, and in the board's view, found that that type of management structure and transfer, for example, did not exist at the Davidson Hotel. And you argue, as I understand it, that those findings are unsupported by evidence in the record.
But I think the core of my argument is that those findings are irreconcilable with Ramada, Beverly Hills because they are not, in fact, inconsistent with what happened in Ramada, Beverly Hills. And if they were viewed to be inconsistent, and I don't necessarily view them to be inconsistent, that they would then be unsupported by substantial evidence. So I'd like to address the specific factual findings of this case and Ramada, Beverly Hills to show the similarities in the key topics that go to determining whether it's appropriate to exclude a unit of employees, like front desk employee. First is functional integration. Both hotels employed a single general manager with final hiring and firing and policy authority, as well as a rotating manager on duty authority system that made the heads of different groups of employees at the hotel in charge of the hotel when the general manager was not there. Second were common terms and conditions. In both cases, there are common terms and conditions that govern all employees. Third is functional integration to perform services for the guests. And here is where I think some of the substantial evidence issue comes in. If you look at Ramada Beverly Hills and other decisions like Atlanta Hilton and Western Hotel, the core to functional integration isn't whether there is some type of job overlap between employees. It's whether all of the employees are being directed by a central management to serve the ultimate goal of the employer at the facility, in this case, to provide a seamless experience for the hotel's guests.
But isn't that true of all hotel employees? When I go to a hotel, I may see the doorman and I ask him, where's the restaurant? And I ask him, who's the best, whatever. So I don't understand this seamless experience when the board has acknowledged that approach, but broken down some of these things. And at least it's found that your general manager did not have the type of control in these units that it held were appropriate. That was true in some of these other hotels. And you're saying that is a finding that is unsupported by substantial evidence?
It is unsupported by substantial evidence in as much as it is viewed as different than Ramada hotels. And I heard 2 points in your question, Judge Rogers. The first is whether all hotels aim to provide a seamless experience for their guests through central management, and I don't think that's necessarily the case.
No, I didn't say that. What I was trying to get at is that all of these hotels, especially these small hotels, are trying to make the guests happy. All right?
I agree with that.
That doesn't mean that there can't be appropriate units.
I agree, Your Honor, that trying to make the guest happy does not mean that it would be appropriate to have any particular bargaining unit. But where there is substantial interaction between the employees, in this case, the board found regular daily interaction between the front desk as well as the housekeeping and food and beverage employees, and there's a centralized management, and the management is virtually identical in Ramada Beverly Hills in this hotel, with the general manager and the manager on duty system. That's the type of functional integration the board has looked at to find that it is not appropriate to have separate bargaining units of the housekeeping and the food and beverage industries.
So are you focusing more on the lack of substantial evidence here or on the board's failure to adequately distinguish its other precedents, along the lines of Lemoyne Owens and other cases like that? Or are those two distinct arguments? I'm not clear from what you're saying if you're viewing them as part of the same argument or if they're two distinct arguments.
I think, Your Honor, our argument is primarily, and I apologize if this was not clear earlier, that the decision here is not reconcilable with Ramada Beverly Hills. So the former. And in response to certain specific factual points, we believe that they are unsupported by substantial evidence. But even if you take the board's findings as a whole, we believe they are still the specific factual findings that it made as opposed to the ultimate conclusions applying the law to those facts are irreconcilable with Ramada Beverly Hills.
And you raised those claims before the regional director as well as the board?
We raised those claims before the regional director and the board split 2-1 on those claims with member Emanuel dissenting. He would have found, as we argued, that the only appropriate bargaining unit at this hotel includes both food and beverage and front desk.
Can I so I understand? I thought your argument was, number one, in the first go-round, the reason that the regional director rejected the two units or the single unit was because it didn't incorporate front desk employees. Is that correct?
That's correct. And we do believe that the decision, the second decision to certify the separate housekeeping and food and beverage units was inconsistent with the reasoning of the NLRB's first decision.
If you had to put the front desk people into the single unit, why isn't that also the death knell for the two unit?
We believe it is. And we believe if you look, and this is on page 231 of the joint appendix, and this is the second inconsistency, Your Honor. If you look at page 231 of the joint appendix, the regional director listed 5 reasons why it was inappropriate to exclude front desk employees. First, they had substantially the same terms and conditions. That applies whether you have separate units for housekeeping and food and beverage. Second, there was regular contact between employees to serve guests. That also applies whether or not you have separate housekeeping and beverage units. Third, the employees were scheduled based on hotel occupancy. That applies equally whether you have separate food and beverage and housekeeping units. Fourth, the employees had the same orientation. That applies equally whether you have separate food and beverage and housekeeping units. And fifth, that there was some interchange between front desk and housekeeping as well as front desk and food and beverage. That applies equally whether you have separate food and beverage and housekeeping units.
Okay, I had a third question to follow up. If in fact the front desk employees, and by law, should have been included in the single unit, and also in the original opinion, the regional director said that it was appropriate to separate out the food and beverage and the room service, or the room people, correct? Then what unit would you put if you have 2 units, which is what was suggested, you can have 2 units, which was what was suggested in the original opinion, what unit, if you tried to put in, the union tried to put 2 units together, or separate the units, what unit would you put the front desk people in?
They would go with housekeeping, Your Honor. That's an alternative argument we've made.
Right.
And the reason...
So let me just understand. But why doesn't that mean that the beverage unit is okay?
Well, and that is our alternative argument, is that if the court doesn't find that the only appropriate unit at this hotel includes food and beverage, housekeeping, and front desk, that alternatively it should find that housekeeping needs to include housekeeping needs to include front desk. They're part of the same rooms division at the hotel, and there's substantial interchange between those units. But in particular, there are substantial similarities there. I would say, as to the consistency of the decisions, we recognize that in an under-reasoned dicta footnote on the final page of the regional director's first decision, he suggests that a separate unit approach may be appropriate, but we believe when you consider the consistency of decisions, particularly in a single case, you need to go to the reasoning of those decisions, not to a footnote on the last page.
But my question remains: why, if accepting everything you just said in your alternative argument, what does that mean that the food and beverage unit is okay?
Yes.
Okay.
I see that I'm out of time. If there are further questions, I'd be happy to answer them.
Thank you. We'll hear counsel for the board.
Thank you, Your Honor. May it please the court, Kelly Isbell here on behalf of the National Labor Relations Board. In making a unit determination, the board's task is to ensure that the petitioned 4 units are an appropriate unit for bargaining. It does not have to choose the most appropriate unit or the only appropriate unit. And this court does not overturn board unit determinations unless Davidson has proved that those units are truly inappropriate, which it has not done on this record. So if we look at each unit individually, the housekeeping unit and the food and beverage unit,
Each of those units, the board determined, share an internal community of interest. They are separately supervised. They have different skills, different functions, different training. Then the board compared those two units to the front desk employees to see whether or not the differences between the housekeeping, the food and beverage, and the front desk, whether or not their differences outweighed their similarities, and determined on the basis of this record that they do. All three, I'll just call them units for sake of ease in speaking, all three groups of employees or units have separate supervision. There is a general manager who is over the hotel, but each one of those groups of employees has a separate manager who is over their work lives, who decides whether or not to discipline them, who has initial hiring authority. Each of those groups of employees has different functions, different jobs within the hotel. They work somewhat different hours. They have different training. The food and beverage people have alcohol and food handling licensing requirements. Front desk employees get customer service training that the housekeeping employees don't get. The regional director found that, yes, this hotel has some functional integration. But when we're talking about functional integration, we're not talking about just whether or not there's a general manager over the hotel. We're talking about whether or not the employees, how closely they work together to accomplish a single task. So housekeepers go clean the rooms. Of course, they work in conjunction with the front desk, because if the front desk doesn't check people into the hotel, there is no room to clean. They put the, I'm sorry, Darrell, were you about to speak?
Yeah. I mean, I guess, on a lot of these, factual determinations about how the hotel works together, of course, the board, we defer to a lot of the board's factual findings in this area. But I'm concerned about the fact that that they raised a number of cases, the cases that were just discussed by petitioner, that the board did not address, right? And it seems that the board has some obligation under Lemoyne Owens and other cases to distinguish other cases. I mean, if they're going to be deciding and adjudicating cases on a case-by-case basis, and petitioner raises cases that are arguably very similar facts, doesn't the board have an obligation to distinguish those other cases? And wouldn't that at a minimum require then at least a remand to the board to distinguish those earlier precedents?
I don't recall that they explicitly raised the issue that the regional director did not distinguish certain cases. I mean, I would have to go back through the decision and direction of election to make sure he didn't mention Atlanta Hilton. But
I think the briefing is pretty clear that they raised these cases and distinguished them in a number of ways.
But I mean a different issue. If the argument is actually that the board failed, and it's for the regional director here, failed in his responsibility to adequately distinguish cases, that has to be raised. But when I don't think
they didn't raise that issue,
that particular legal issue, no, Your Honor.
Are you talking raising before the board or raising in this court?
Raising before the board.
Right.
So they have to file, if they believe the regional director made either an incorrect factual finding or an incorrect legal finding, they have to raise that before the board. And they filed exceptions to the regional director's decision and direction of election. But the regional director went through many cases and showed why this is not the kind of case where functional integration required him to put all these employees together. Functional integration in a case like Atlanta Hilton, the general manager there had control over minor details such that he was controlling how elevator doors were cleaned. In Ramada, Beverly Hills, there was substantial interchange between employees. Housekeeping employees and bell staff who were attached to the front desk were both delivering food throughout the hotel. Bell staff and front desk assisted with housekeeping. So those kinds of findings are just not here. The front desk, I think the testimony is that maybe 3 times a year when the hotel is severely overcrowded, they might have to strip beds. But cleaning hotel rooms is not part of their job.
The housekeeping group does not fill in for the front desk. They do not do anything at the front desk. Food and beverage employees don't assist the housekeepers. What we have is a little bit of contact, which the regional director acknowledged, and some functional integration because it is a hotel and everyone is trying to ensure that there is a good guest experience. But doing a particular task, like preparing a meal or serving a drink or cleaning a hotel room, you do not need the front desk to come and help you do that. You need them to check in people. You need them to do their own work. And that's the difference between the kind of functional integration in a case like Atlanta Hilton or Ramada Beverly Hills. Okay. So here, the board did two types of analysis, right? You first have to determine that the employees in the petition for unit share community of interest. Clearly they do. Housekeeping and food and beverage units are traditional industry units. Then it looked at whether or not they are different from the front desk. Just sharing similar terms and conditions of employment is not enough to require the board to put everyone together, and it does not show that the units are truly inappropriate. They use the same parking lot, they use the same cafeteria, they clock in at the same time clock, but they do not have the same supervision. They do not have the same hours necessarily. They don't do the same jobs. So I'm not sure if your honors have additional questions for me on this issue. Should we talk a little bit about the first case? I think there was some concern about the initial regional director's decision here and why the two cases are different and why they came out differently. In the very first case, the union petitioned for a combined unit of housekeeping and food and beverage, leaving out the front desk. The regional director did the same analysis he did here. Do those two groups of employees share a community of interest? Yes. Same terms and conditions of employment, same parking lot, same time clock, the same general manager. But when you compare them to the front desk, that's when the differences appear. Because the front desk also uses the same time clock, same cafeteria, same parking lot, have almost the same terms and conditions of employment. I'm sorry.
So I was just looking through the materials here, and it does seem that they raised this question about the departure, the regional director's departure from board precedent before the board. And it's request for review. They say in one of their headers, and then have further discussion, substantial question exists concerning the legality of the unit based on the RD's departure from the board's precedent. So it does seem that they raised it before the board.
And my apologies, because sometimes those requests for review can be a little long and I don't remember everything. I think the regional director here adequately distinguished the precedent. Remember, hotel cases, almost every unit determination case, they're decided on the facts and they're decided on a case-by-case basis. And the regional director was very clear about why he made the functional integration decision he made in this case. He relied on cases that are very similar to this case, and the fact that he didn't distinguish very specific cases, I don't think that does not show that he didn't do his due diligence in reviewing the law in this area and applying that law to these facts, which show that there is not enough functional integration to require the board to find that individual units of housekeepers and food and beverage are truly inappropriate. Remember, it just has to be an appropriate unit for bargaining.
What was the regional director's rationale for not including the front desk employees in either the beverage or the housekeeping units?
First of all, you start with the petition for a unit, right? So that's your starting place. And the front desk employees have no more community of interest with either group. They have similar terms and conditions of employment, but there's nothing that would require them to be in either group. They are separately supervised from the housekeeping employees. They're in the same room division, but the room division has no manager. They are each supervised by a separate, either the front desk supervisor or the housekeeping supervisor. And those two people report to the general manager. So they're at the same level of, and other than that, in the same, terms and conditions of employment, time clock, parking lot, some interchange and some interaction during the day.
You realize that what you've just said is totally inconsistent with the original decision saying you had to include the front desk employees.
The original decision said that you couldn't have a unit that was a combined housekeeping and food and beverage without the front desk, because what they share, what all three groups share, are the same. Does that make sense? I'm thinking of the Blue Man
No,
terms and conditions of employment. Okay, so you've got three groups of employees. They all share some things in common. Some terms and conditions of employment, they all report to the general manager. They all work at the same hotel. Each group shares those same things. But each group also has its own internal community of interest, which makes all three groups different from each other. So if you take two of those groups and put them together, what they share, they also share with the third group. So if you put front desk and food and beverage together, they do share some terms and conditions of employment and some community of interest factors. But what they share, they also share with the housekeepers. The differences between the three groups outweigh the similarities. That's the basis of the board's findings. In the first,
like this rock is heavier than that string is long.
If you want to put it that way, right? I mean, sharing some of the same terms and conditions of employment, because remember, the front desk now has higher wages and lower medical costs.
Okay, I think I got your argument.
Thank you. If there are no more.
So to respond to what I think I understand is petitioner's argument, it said to the regional director, "You're just like Ramada, Beverly Hills." And the board never said, "No, you're not." What it did was to cite its decisions that discuss Ramada, Beverly Hills, Ramada, Atlanta, and a number of other hotels, identifying the factors. The board interpreted those precedents to focus on. What I think I hear an argument, and I'll ask counsel for petitioner, is that, and I heard my colleague discuss a Supreme Court case, it wasn't cited either, but to the board. But the question is, from the point of view of this court's review of the board's decision, is it legal error in the sense of being arbitrary and capricious if the board cites to authority distinguishing its precedent, but doesn't specifically say, and your reliance saying that you're exactly the same as Ramada, Beverly Hills, is arbitrary and capricious? In other words, there has to be a separate paragraph, as it were, saying that petitioner is relying on Beverly Hills, and we don't think that is a proper case on which to rely. Even though in the cases we did cite, we pointed out why Beverly Hills is different. I just want to be sure what we're saying the board has to do in response to the type of argument that was raised before the board by petitioner as to Beverly Hills.
Right. I don't know of any case that would require the board to specifically address every single case raised. The board is required to do reasoned decision making. And on this record, I don't think that can be assailed. The regional director reviewed multiple cases and laid out all of the factors that the board traditionally relies on in making community of interest decisions. And as you point out, Judge Rogers went through cases that had themselves distinguished Atlanta Hilton and Ramada Beverly Hills in cases like this.
I'm trying to understand what the rule would be were we to say that it would be inappropriate for an agency to cite its precedent, including that precedent on which petitioner relies, where petitioner is saying, essentially, we're just like Beverly Hills. I'm just trying to understand what the administrative principle would be here in that regard, because that's sort of what I hear petitioner counsel arguing today and in its brief. You didn't talk about Beverly Hills. Therefore, your decision is arbitrary and capricious.
That may, in fact, be a better question for petitioner's counsel, because I don't know of any I'm sorry?
I just wanted to be sure, since I won't be coming back to you, I am going to ask petitioner's counsel, but based on the questions from my colleagues and from me, to be sure we understood the argument that petitioner's counsel is making, I wanted you to have an opportunity to say why that principle either is required or isn't required.
I don't believe it is required, Your Honor. I mean, the board is required to engage in reasoned decision-making. I don't know of any case that requires the board, and in a case where it is reviewing totality of circumstances tests to determine unit determinations, that it has to address very specific cases. Of course, if this were a case where someone raised PCC structurals and the board somehow didn't address the underlying unit determination test in this case, that's a different issue. But we're talking about very specific factual cases that the board, I don't know of any administrative law principle that would require the board to literally distinguish every single case.
Every single case. That's what I'm trying to distinguish on.
Mm-hmm.
Petitioner says, you're wrong for all kinds of reasons, and says, your decision is inconsistent with Beverly Hills. And the board's response is, look at what we've said about Beverly Hills and all these other cases in this opinion. And they cite that.
That is enough, Your Honor.
So, counsel, excuse me, did my colleagues have any further questions?
I don't.
Counsel.
Thank you.
All right, an intervener comes next, I believe.
Yes, thank you. So first, I'd like to situate the two cases that the employer relies primarily upon, Ramada Beverly Hills and Atlanta Hilton, within the historical context of Nlrb decision-making in this area. For 50 years, since at least 1970, the Nlrb has found regularly, consistently, that front desk employees are different. They're different because they don't do the manual labor that housekeepers and food and beverage employees engage in. And if you look at the cases the party cites and the cases cited within those cases, by a margin of about 2 to 1, front desk employees are excluded. So this is not a situation where the Nlrb has gone back and forth on major rules, like we've seen with graduate students, for example, being covered by the NLRA. This is a case where there has been remarkable consistency for half a century.
And so the original decision by the regional director was wrong.
That may be true. That's not what's at issue here.
It's at issue because to the extent that that the same regional director, Mr. Orr, should have distinguished or confessed error in the second go round.
So, Your Honor, the first decision arose out of a petition that the union filed. The union preferred a combined unit of housekeepers and food and beverage employees, but the regional director found that the commonalities between those two groups of employees were also shared with front desk employees. And so it would make sense to have those two to the exclusion of the third. They would have that didn't make sense to the regional director. And that's consistent with the second decision, because once you separate those groups out, their internal communities of interest do differ enough from each other group that they can be bargained separately. And that's what's important here is, are we going to have a stable bargaining relationship? Is the union securing the collective goods for each group of employees that makes sense? I mean, housekeepers have different interests from food and beverage employees, and who have different interests from front desk employees. And so that's what's important to keep in mind here. So not only is there consistency across 50 years of case law, there's consistency between the two decisions of the regional director. Housekeeping employees, they work alone in rooms. They have different tools. They deal with cleaners. And so these are common areas that a union would bargain over, that it wouldn't bargain over with front desk employees. And so the internal interests of each group are distinct and can be bargained separately. To the employer's point that these will be functionally treated as a single unit, that is not supported by the record. And in fact, if the employer insisted that they be bargained separately, the union would have to do that. It has a duty to bargain for each unit. That's what a bargaining unit is. So if the employer doesn't want them to be treated as one unit, it doesn't have to. It would be an unfair labor practice for the union to insist on that. I also wanted to clarify, the employer brought up an unfair labor practice charge that the union filed, and saying that the employer could not go through with benefits changes. If you look at those cases, Banner Care and Mercy Hospital, that is absolutely not true. If those were scheduled, the employer could go through with them. And in fact, that charge was dismissed because the region found that those wage increases and benefits changes had not been scheduled. So we're left with discretionary wage increases that the employer gave to only front desk employees. It's treated them differently. Shows they have a different community of interest. I see that my time is up. If you have more questions, I'd be happy to address them.
All right, I don't see any questions. Counsel for petitioner? Would you like to offer rebuttal?
First, I'd like to unmute, and now I'd like to offer rebuttal. And I want to start with the question that you asked my colleague, Ms. Isbell, and that is, when does the board have to address a precedent? And Ms. Isbell said, I think, what is essentially the right test. It has to be reasoned decision-making by the board. But she also noted that you can't ignore the elephant in the room. She said you can't ignore PCC structurals on community of interest, for example, because it's just too important. And I agree with that as well. And in this case, Ramada Beverly Hills is that important due to the close similarities between the facts of the Davidson Hotel in Chicago and Ramada Beverly Hills. I don't think that we're dealing a lot with standards in this case as opposed to rules, and I don't think that there is a crystal clear rule about when a specific case has to be addressed, but when it's as close as Ramada Beverly Hills is to this case, for the board's decision to be reasoned, it does have to address it. The regional director.
So what I'm trying to focus on, and I think you misunderstood my question to counsel for respondent. My point is that if, in this case, the employer says, we are just like Ramada, Beverly Hills, and the board's response is to cite a case in which it discusses Ramada, Beverly Hills, and a number of other cases in this same area, hotel cases, small hotel cases. Are you saying that there can be no reasoned decision making when the board does that, because there must be a separate statement specifically saying, and this case is not Ramada, Beverly Hills?
In this case, because it's so close, I think that there does need to be a separate statement. I don't think that's a general rule for every case, but if you look at the regional director's decisions on JA 304, continuing on through JA 343, it's never mentioned. We raised it in exceptions to the board, it's never mentioned.
He cited cases that discuss. That's what I'm trying to get you to focus on. It's like the Supreme Court decides a case on day 1, and then it decides another case on day 2. And then another case comes up on day 3. And so the court cites to its day 2 decision, which discusses its day 1 decision. Why isn't that adequate for reasoned decision making? And your response is, no, there has to be a separate paragraph on the day 1 case. And I'm trying to understand what the rationale is behind that.
Rationale is due to how similar the facts of the case, the day 1 case in your hypothetical, and the instant case is. That's the distinguishing factor. I see that I'm out of time. I had a few other brief points if the court is interested in hearing them, but if not, then I would rest.
Sure.
First, I'd like to address the point about the internal communities of interest within food and beverage and housekeeping. Many of those were not, in fact, unit-wide interests. Ms. Isbell mentioned the alcohol training. That's something that some parts of the food and beverage units got, like the servers and the bartenders, but not other parts of the unit, like the cooks and the stewards. So those aren't the type of communities of interest that could outweigh the strong interest that front desk employees with the same terms and conditions of employment share with other members in the unit. And finally, back to Ramada Beverly Hills, there was some question about the degree of interchange. And again, the facts are very similar. In that case, there was evidence of the bell staff assisting the housekeepers. That happens with regard to the bell staff at this hotel, which there's undisputed, also share responsibility for cleaning the parts of the hotel where they work. There's mention of assistance between the food and beverage. And in this case, there was substantial assistance with front desk and food and beverage for banquet events. So there was one employee who worked, I believe, 150 hours. Front desk employee worked 150 hours in the food and beverage banquets business over a 2-year period relevant to the organizing. These sort of picayune distinctions in the facts, every hotel is a little bit different, like every fingerprint's a little bit different. But those type of picayune factual distinctions are not a reasoned basis for distinguishing the cases. Thank you.
Thank you. We'll take the case under advisement.
This honorable court is now adjourned until Friday, September 11th at 9:30 a.m.
Goodbye.